My name is Severina McGill, and this module is for the ePathshala, UGC. The content writer was Meher Dev. This module is on Hindu marriage law. By the end of this module, participants should be able to understand the difference between personal laws and secular laws, contextualize the Hindu Marriage Act from 1955 within its legislative and political history, analyze the body of Hindu law that is applicable to the marriage and divorce of Hindus, understand the elements of a valid Hindu marriage, recognize the difference between void and voidable Hindu marriages, recognize the grounds for divorce under Hindu law, and understand the difference between divorce and judicial separation, and know how courts have started to give legal status to live-in relationships, particularly when one party claims maintenance. India is a diverse, pluralistic country and home to people of different faiths. The Constitution of India recognises the right to one's religion and right to preserve one's culture as some of the fundamental rights of Indian citizens. India's plurality and diversity have manifested themselves in laws as well. Marriages and divorce in India, as well as other practices such as inheritance, are governed either by personal religious laws or by secular laws. Personal religious laws may be defined as the body of laws which apply to a person solely on the ground of that person belonging to a particular religion. Secular laws are basically legislations enacted by the Parliament on marriage and divorce which are not specific to any religion and can be made applicable to a citizen irrespective of his or her religion. Personal religious laws apply to persons by default and may be codified or uncodified. Most of Hindu personal laws are codified, and the law governing marriages and divorces for Hindus is the Divorce Marriage Act from 1955. Secular legislation does not apply by default, and to be governed by secular law, persons have to opt for it at the time of their marriage by registering their marriage under the equivalent secular law, such as the Special Marriage Act. For example, Hindus can opt out of the personal law of the Hindu Marriage Act by registering their marriage under the secular law of the Special Marriage Act from 1954. Secular laws are of course of particular importance for couples who choose to marry when the individuals belong to different faiths. The legislative history of the Hindu Marriage Act from 1955 starts with Dr. B.R. Ambedkar, who had a dominant role in drafting the Indian Constitution. He became the first Law Minister of India, with Jawaharlal Nehru as the first Prime Minister of India. Under the Nehru-led government, a committee was formed with Dr. B.R. Ambedkar as its chairperson. This committee was tasked with the responsibility to codify Hindu personal laws. The committee formulated and drafted legislative bills which were called the Hindu Code Bill. These aimed at codifying all Hindu personal laws governing matters of marriage, divorce, adoption, maintenance, and custody. The Hindu Code Bill received great opposition from the then President of India. Dr. Rajendra Prasad and several congressmen didn't like the codification of the Hindu bills all at once. Many people saw the Hindu Code Bill as an intrusion into their religion. Due to the opposition and deferment, Dr. B.R. Ambedkar resigned in protest in 1951, and the Hindu Code Bill lapsed due to re-elections. In 1952, the then Law Minister C.C. Biswas moved the Parliament for passing of the Hindu Code Bill. The members of the Parliament realised that it was an impossible task to pass and enact the Hindu Code Bill all at the same time as an entire document, and thus decided to segregate it into 3 different bills. The first was the Hindu Marriage and Divorce Bill, the second was the Hindu Adoption and Maintenance Bill, and the third was the Hindu Succession Bill. The Hindu Code Bill was finally enacted in 1955. The Hindu Marriage Act from 1955 earlier formed part of the Hindu Code Bill. This was enacted to amend and codify marriage and divorce laws between Hindus, thus hoping to make them consistent across the country. The Hindu Marriage Act, being a codification of Hindu personal law, is not applicable to all citizens of India, but only to Hindu citizens. The applicability of the Hindu Marriage Act is wider than it appears, as it also applies to all Indic religions, including Sikhs, Jains, and Buddhists. Section 2 of the Hindu Marriage Act explicitly makes the Marriage Act applicable to all the other Indic religions. Though there were objections raised in Parliament against such wide application of the Act, the law, when passed, continued to carry Section 2. To date, many authors and citizens from the communities of Sikhs, Jains and Buddhists continue to criticise Section 2 for its applicability to minority religions, and see this law as an intrusion into the religious affairs of minority religions. It is important to note that the Hindu Marriage Act from 1955 is also applicable to a person who has converted or reconverted to be a Hindu, Buddhist, Jain or Sikh. The Hindu Marriage Act is also applicable to legitimate and illegitimate children, where either one or both of the parents are either Hindu, Buddhist, Jain or Sikh by religion, or one of whose parents belongs to one of these religions, or if the child was brought up as the member of a tribe, community, group or family to which such parents belong or did belong. By virtue of Section 4 of the Hindu Marriage Act, this codified piece of Hindu personal law overrides any uncodified Hindu personal laws that run contrary to its codified provisions. The Hindu Marriage Act forms the sole source of Hindu personal law on marriages and divorce. The Act covers the conditions of a valid marriage, void and voidable marriages, and the registration of marriages. Conditions of a valid marriage are found in Section 5 of the Act. Section 5 specifies the conditions that must be met for a valid marriage. A marriage between two Hindus is considered as valid if the following conditions are met. First, neither party should have a spouse living at the time of the marriage. Bigamy is prohibited under Section 17 of the Hindu Marriage Act and is a punishable offence under provisions 494 and 495 of the Indian Penal Code. Second, at the time of the marriage, neither party should be incapable of giving their valid consent to the marriage in consequence of unsoundness of mind, or capable of giving a valid consent has been suffering from mental disorder of such a kind or to such an extent as to be unfit for marriage and the procreation of children, has been subject to recurrent attacks of insanity or epilepsy. Also, for a marriage to be valid, the bridegroom must have completed the age of 21 and the bride must be 18 at the time of the marriage. The parties must not be within degrees of prohibited relationship, for example, a close blood relationship, unless the custom or usage governing each of them permits a marriage between the two. The parties are also not allowed to be sapindars of each other, unless the custom or usage governing each of them permits a marriage between them. Section 7 of the Hindu Marriage Act from 1955 states that a Hindu marriage is solemnized when undertaken in accordance with the customary rites and ceremonies of either party thereto. The majority of Hindu marriages require 7 steps by the couple jointly around a sacred fire for the marriage to be solemnized. Under Section 18 of the Hindu Marriage Act, failure to meet certain conditions to marriage prescribed under Section 5 of the Act may lead to punishment in the form of simple imprisonment, which may extend to 1 month, or with fine, which may extend to 1,000 rupees, or with both. If conditions mentioned under Section 5 are not met, the marriage is either void or voidable under Sections 11, 12 and 17 of the Act. A void marriage is a marriage that has no legal status from the commencement, and a voidable marriage is a marriage that has legal status until the time a court of law passes a decree of annulment. If conditions 1, 4 and 5, as listed above, are not met, then the marriage will be void. If condition 2 is not met, then the marriage will be voidable. Further, if the bride is pregnant with the child of another man, or the marriage is not consummated due to impotency, then the marriage is voidable. Section 8 of the Hindu Marriage Act provides for registration of marriages, but such registration is not mandatory, and failure to register does not make the marriage invalid. Registration of marriage leads to an entry of the particulars of the marriage into the Hindu Marriage Register. This is maintained by state authorities. This registration serves as evidence of marriage. Some state legislation have amended Section 8 of the Marriage Act and made rules for registration. The Supreme Court of India and the High Courts have recommended that registration of marriages should be made compulsory. Divorce under the Hindu Marriage Act also applies. Divorce under the Hindu Marriage Act is also covered. It determines who can divorce, when they can divorce, and where they can file for divorce. The Act entitles both the husband and the wife to file a petition before a court of law for divorce. A divorce petition can only be filed in a court of law after 1 year from the date of the marriage has elapsed. The reason behind this is that marriages in Hinduism are considered to be sacred, and it is believed that the couple should attempt to make the marriage work. In exceptional circumstances, courts of law may admit a petition before the completion of 1 year of marriage. A petition for divorce shall be presented to the district court within the local limits of whose ordinary original civil jurisdiction applies. This is determined by 1. Where the marriage was solemnized. 2. Where the respondent at the time of the presentation of the petition resides. 3. Where the couple to their marriage last resided together. Or 4. Where the petitioner is residing at the time of the presentation of the petition. In a case where the respondent is at that time residing outside the territories to which the marriage took place or extended, or has not been heard of as being alive for a period of 7 years or more by those persons who would naturally have heard of him or she if they were alive. Further, Section 23 of the Hindu Marriage Act mandates that courts of law, before granting any relief under the Act, endeavour to bring about a reconciliation between the parties, and refer the matter for reconciliation to be undertaken within a reasonable stipulated period of time. However, this duty of the courts of law is not applicable if relief is sought on any of the grounds specified in Section 13, Section 1, Clause 2 to 7. These grounds include conversion to another religion, unsoundness of mind, or if a husband has been missing for 7 years, if there is incurable disease or a renouncement of the world. A Hindu man or woman may petition for divorce on the following grounds as prescribed under Section 13, Clauses 1, 1a, and 2. These include adultery, if the husband or wife has had voluntary sexual intercourse with another man or another woman; cruelty, where the husband or wife has suffered from physical or mental abuse; desertion, where the husband or wife has been deserted for a continuous period of not less than 2 years; conversion to another religion, where the husband or wife has ceased to be a Hindu and has adopted another religion; unsoundness of mind, where the husband or wife has been diagnosed since the marriage ceremony as being unsound of mind to such an extent that normal married life is not possible; disease, where the husband or wife has been diagnosed with an incurable form of leprosy or has the venereal disease in a communicable form; presumption of death, the husband or wife has not been seen alive for 7 years or more; no resumption of cohabitation between the husband or wife after a decree of judicial separation for a period of at least 1 year has been granted. Further, a wife may seek a divorce also under Section 13(2) on the grounds that 1. Another wife of the husband was alive at the time of the marriage ceremony; 2. The husband has been convicted of rape, sodomy, or bestiality; or 3. Cohabitation has not been resumed within a year after an order for maintenance under Section 125 of the Criminal Code of Procedure; or, alternatively, under the Hindu Adoption and Maintenance Act from 1956. If a wife was not a major when she married and wishes to repudiate the marriage before attaining the age of 18, a decree for separation may also be given. Pursuant to Section 13b of the Hindu Marriage Act 1955, both the husband and wife together can claim divorce on the grounds of mutual consent. The Supreme Court in 2006 recommended to the Union of India that it should amend its Hindu Marriage Act to incorporate another ground for divorce in the following words: a Hindu who has been divorced can marry again once the divorce has been finalized. That is, once the period of filing an appeal against the divorce has expired, or the appeal, having been filed, has been dismissed. The courts of law can, using their discretion, treat a petition for divorce as one for judicial separation. Judicial separation means that a couple is living separately pursuant to a court order being passed, but the couple is still legally married. Such a court order can be procured by the husband or wife by filing a petition praying for a decree for judicial separation on any of the grounds specified under Section 13(1) and 2. Under Section 28 of the Hindu Marriage Act, court decrees granting or refusing divorce are appealable by both the husband and wife. Whoever is unsatisfied with the court decree within 30 days from the date of the court decree. It is important to note that a court decree is not automatically enforceable. Pursuant to Section 28A of the Hindu Marriage Act, all court decrees and orders in marriage or divorce proceedings shall be enforced in the like manner as the court declares, and such orders or decrees made in the exercise of their original civil jurisdiction for the time being are enforced. Live-in relationships are where two adults live together and are in an intimate partner relationship. Live-in relationships seem to be increasing and are most prevalent in urban cities. Whilst marriage is the norm in Indian society and confers on the married couple legal rights and duties, couples in live-in relationships were only recently given legal rights. As India does not yet have same-sex marriage laws, recognition of live-in relationships currently only extends to heterosexual couples. Recognizing that a couple in a live-in relationship share a similar relationship to that of a marriage, the Supreme Court of India recommended to Parliament that women in live-in relationships be given legal rights similar to that of married women. Until the Protection of Women from Domestic Violence Act in 2005, there was no law recognizing the existence of live-in relationships, and legal rights for unmarried women were often denied by courts. If a married or divorced woman wants to claim maintenance from her partner, she can seek maintenance under Section 125 of the Criminal Code of Procedure, the CRPC. In 2005, the Supreme Court decided in the Savita-Ben case that unmarried women were not entitled to claim maintenance. The appellant had claimed that she was married to the respondent according to the customary rites and rituals of their caste. The court then stated that strict proof about a valid marriage is not the sine qua non for getting maintenance under Section 125 of the CRPC. Despite recognizing this, the respondent claimed that he had previously married a different woman, and therefore the appellant's claims that she was married to him could not be true. The court then said, even if it is accepted, as stated by learned counsel for the appellant, that the husband was treating her as his wife, it is really inconsequential. It was ruled that the CRPC only gives maintenance to legally wedded wives and not to live-in relationship partners. The court then dismissed her claim for maintenance, but did allow the case of maintenance for the now deemed illegitimate child. The Savita-Ben case demonstrates how even in the same year that the Domestic Violence Act was enacted, recognizing live-in relationships, the Supreme Court was not readily granting them recognition. In 2010, the D. Velusamy v. D. Pachiyamal case, the Supreme Court, again in a claim for maintenance, stated that for a relationship to be recognized as akin to a common law marriage, the relationship must be in the nature of marriage. The court then laid down several criteria for a relationship to fulfill if it was to benefit from legal recognition. These criteria were: A. The couple must hold themselves out to society as being akin to spouses. B. They must be of legal age to marry. C. They must be otherwise qualified to enter into a legal marriage, including by being unmarried. D. They must have voluntarily cohabited and held themselves out to the world as being akin to spouses for a significant period of time. Before reaching the decision that maintenance was owed to the woman, the court also looked at laws abroad, like America, where palimony exists. In 2013, in the Indra Sharma case, the Supreme Court held that a live-in relationship would amount to a relationship in the nature of marriage, thus coming within the definition of a domestic relationship, as found under Section 2F of the Domestic Violence Act, if the following criteria were fulfilled: the duration or period of the relationship, B. the pooling of resources and financial arrangements, C. domestic arrangements and division of household work, D. sexual, emotional and intimate relationships, and having children, socialization in public, and F, the intention and conduct of the parties. These two cases demonstrate how the judiciary has started to accommodate the legal rights of women in live-in relationships to claim maintenance in recent years. In 2011, a case went to the Supreme Court whereby a woman wanted to claim maintenance from her husband after they separated, after many years of living together, but they were not legally married. While adjudicating upon the maintenance claim in the Chonomaya versus Chanmunia Virender Kumar Singh Kushwaha and another case, the court had to decide upon the issue of presumption of marriage when the parties lived together for a long period of time without a valid marriage existing. The court, whilst questioning the definition of wife under Section 125 of the CRPC, stated, "We are inclined to take a broad view of the definition of wife, having regard to the social object of Section 125 of the Code of Criminal Procedure." By referring to the social object, the court stated that Section 125 of the CRPC is meant to achieve a social purpose, and the purpose is to prevent vagrancy and destitution. Therefore, to not recognize the woman's status as a wife of her partner, the court would not pursue the interests of social justice, as it would leave the woman vulnerable to financial insecurity and potential destitution. The case marks a departure from the court's earlier thinking in the Savita-Ben case. The above case demonstrates that recently there has been a will from the courts to protect women from perceived destitution and to extend the reach of law to secure their livelihoods. However, this accommodation of law has not been consistent, and it is only since 2010 that there has been more holistic inclusion of women as live-in partners. As the position stands today, Hindu personal laws are in a codified form. There exist enacted legislations on matters of Hindu marriage, divorce, adoption, succession, and maintenance. The advantage of having Hindu personal law codified is that the chances of misuse of personal laws is relatively lower, as the codified legislations are explicit and clear in language. Also, divorce being a court-driven process prevents divorce being given on grounds other than those which are reasonable. This module has covered both marriages, void and voidable, and the status of live-in relationships under Hindu marriage law.